As the board knows and the public knows, we as a township have been involved in incredible litigation for over a year. And I'll just refer to it as the Carla Mader lawsuits that were filed against this township. It all started with the Cardox Road project. And what's normal is you identify a project, you bid the project. If you agree with those numbers, you go out, you engineer it, you get easements if you have to go onto people's property, either permanently or temporarily. That's just the way road projects are developed. And in this instance, everybody but the Maders and the Neodex, agreed to the easements that we needed to work. In order to keep the project moving, we filed, and it's a standard, eminent domain proceeding, saying, okay, we need to go onto your property, or we need to take some trees, or whatever we need to do to make this project uniform and also to make it safe. And if you think you're entitled to damages, there's a form. Eminent domain permits you to come in with your appraisals, and if a board of you agrees, that's what we pay you. That's what eminent domain proceeding is all about. And the reason I'm going to spend some time on this is because this township has incurred tens and tens and tens of thousands of dollars in legal fees. I just answered a right to know request where someone asked for my bills, and you'll see how extensive that is, and I'm just only one of the 5 or 6 attorneys involved in the litigation. It's a lot of money, and it's taxpayer money. But I want to let you know what we've had to defend, because you just don't sit back. If somebody files a lawsuit against you, you're required to respond, so there's not a default judgment. And in this case, once we filed our eminent domain actions in state court, the Maders and the Neodex filed preliminary objection. Now, preliminary objection is challenging the validity of that eminent domain proceeding. At the same time, they filed a federal lawsuit in the Western District Court in Pittsburgh. That lawsuit named the township, every sitting board member, me individually, Mr. Crooney individually, our zoning officer at the time individually, Harshman individually, and the demand was for $6 million because we violated their constitutional rights. All right, if any of you were sued for that amount of money, believe me, you'd come out with both barrels blasting to defend yourself, and that's what we did. We have an insurance carrier and a major firm in Pittsburgh defending us partially on these matters. So once this lawsuit was filed, we turned it over to our carrier. Marshall Dennehy, attorney Scott Dunlap, entered their appearance and took over that portion of the lawsuit in federal court. At the time the complaint was filed, we learned that the Maders had also filed a Chapter 13 bankruptcy reorganization. Now, under bankruptcy law, anytime a petition is filed, all proceedings involving that individual or that company have to stop. So we had no choice but to go into bankruptcy court. The case was assigned to Judge Tadanio. We filed a motion for relief from stay. At the same time, Mrs. Mader and her group filed a motion for sanctions against us in both federal court and state court for exercising our due process rights and asking for $4,000 in damages. There was an argument before Judge Tadanio. He issued a court order denying the Mader's motion for sanctions, and he issued a court order lifting the stay and permitting the township to proceed with the eminent domain actions in state court. That involved time, it involved legal expense. Second part, once we were in federal court, we once again engaged in our right of discovery. That's where you ask questions: what's your case about? What are your damages? What are the accusations? What proof do you have? And we're entitled to take depositions. The Maders filed a motion with Judge Christine Wygand, who's the federal judge handling this case, seeking a motion for protective order to prevent us, our group, from taking her deposition. This was denied by the judge. Next, Anthony Pellegrino, a non-attorney, not licensed, and connected to this mystery group, E-Clause, whatever that is, entered his appearance in both federal and state court to represent the Maders and the Neodex. Once again, we filed a motion to strike his appearance. The judge issued an order and a decision saying that he is absolutely forbidden from representing the Maters as a non-licensed, non-practicing attorney. Next, the Maters filed a request for a temporary restraining order in August of 2020. The restraining order was to prevent us from doing anything. Once again, the court, by order dated October 30th, after briefing and argument, denied it. The Maters then filed a preliminary injunction in federal court to prevent the township from proceeding with its action. Now, you need to know that the reason this whole thing stopped is once we got on Cardox Road and attempted to do work within our legal 33-foot right-of-way, our contractors were chased off. Our contractors were threatened with suit. The police came and couldn't talk sense. Our contractors left. Believe it or not, those contractors were also named in the federal lawsuit, so they had to hire attorneys and defend themselves. Once the preliminary injunction was filed with Judge Wigan, she ordered initially mediation. Let's try to get this thing resolved. Let's let cooler heads prevail. We want both sides to present a proposal to settle this in the form of a consent agreement. Our side did that. It was a very reasonable. In fact, all we were asking is that we be permitted to work within our legal 33-foot right-of-way, which is black letter horn book law. You don't need anybody's permission. We weren't able to enter into a consent to settle. The judge then ordered mediation. She appointed former County Judge Scanlon to act as the mediator. We had a day and a half of mediation. We incurred thousands of dollars with the mediator's expense, the stenographer, legal time, and Judge Scanlon believed that our proposal was reasonable. It was not agreed to after 8 hours of mediation, going from room to room to room. No result there. As a result, Judge Wigan scheduled a full day hearing where multiple witnesses were, and before this, there were like 7 or 8 depositions that were taken as part of the preliminary injunction hearing. Full day of hearing. About a month after the hearing and the record was closed, the judge issued a 13-page decision denying Mater's motion for a preliminary injunction. Okay. And I have all of the decisions. At some point in time, I'd be happy to let anybody that wants to look at this and read it, because they're a matter of public record. I'm just referring to what is of record. After that, the Maters filed a second motion for a temporary restraining order with the same judge, asking her to issue an order stopping us from doing anything in state court. The judge issued another extensive opinion denying her motion and ruled that under the anti-injunction statute and the Younger case, which is a federal case, that the federal court had no authority to intervene in what was a distinct state court action, eminent domain, that governed the police powers and legislative powers of a municipality, okay? So the judge has said, no, you can't have any of this. Now, this is a year later and tens of thousands of dollars, but every one of those orders was in favor of the township. The township, because it needs to complete this road. It's a safety issue because it narrows at that point. In fact, the Ringgold School District won't even let buses travel that road, and that's why it's been blocked off. And we're that close to having it done. We filed a complaint for a permanent injunction that would prevent them from interfering with us doing our job within our 33-foot right-of-way. That's the hearing in front of Judge Emery on May 20th. I can tell you we've done all of this with tens of thousands of dollars of legal expenses, and we haven't even gotten to the federal lawsuit complaint because we've had all these preliminary skirmishes. The next step is a possible motion to dismiss, extensive discovery, depositions, and possibly a jury trial in federal court on that complaint if any of the counts are upheld by the judge. So I just wanted the public to be aware of what has been going on and what we've been required to do. And I have to say, that's with taxpayer dollars.
Insurance company, we got a pause, but
We don't know what the future holds next year. I mean, I know that the insurance company has paid $150,000 in legal fees so far. They've paid that. That's not the township's checks that they wrote, but $150,000 thus far for our defense. And we're right, we're winning every one of these motions, but I'm extremely concerned at the position the insurance carriers are gonna take next year when it comes time to renew. Will they even write a policy? If so, can we even live with the policy? Because they could make a deductible of $50,000 on every claim. Our deductible's been anywhere from $2,500 to $5,000. That's what insurance companies do. So, you know, I'm holding my breath on that to see what impact these cases have on our insurance coverage. So I'm sorry to belabor that, but I thought it was important to bring it to.
It is. Thank you, Gary. Gary, do you have any more?